All right, good afternoon, everyone. My name is James Tatum, and welcome to the Council of State Governments webinar reviewing the regulatory implications of the North Carolina State Board of Dental Examiners versus the FTC case of 2015. Today, I'm joined by Ron Jacobs, the chair of the political law practice at Venable LLP, Mike Armstrong, CEO of the National Council of Architectural Registration Boards, and Corey Everett Miskell, the Colorado Director for the Latino Coalition for Community Leadership. Just a bit of housekeeping before we start today. Closed captioning is available, and if you have technical difficulties or if you have a question about Zoom, please use the chat feature to type a question, and a CSG staff member will get back to you as soon as possible. To ensure our speakers can be heard clearly, all participants will be muted during the meeting. This meeting is being recorded, so by continuing to participate, you are consenting to this recording. The recording will be available to view on our website at compacts.csg. This will be at licensing.csg.org. And our speakers and presentation, after the presentations, there will be a question and answer session. So please submit your questions in the chat feature, which will be monitored throughout the meeting. Now, just in case you wanted a refresher on CSG, some background on us: we were founded in 1933, and we are the nation's only organization serving all three branches of state government. We have a unique ability to convene state leaders and stakeholders to develop and share best practices and policy solutions. And our mission is to champion excellence in state government in order to advance the common good. This presentation is funded by a grant awarded by the U.S. Department of Labor's Employment and Training Administration, and the Occupational Licensure Project has been a collaboration between CSG, the National Conference of State Legislatures, and the National Governors Association since 2017. Our project goal has been to identify licensing criteria to ensure that requirements are not overly burdensome or restrictive, and to improve portability and reciprocity. All of our project materials, publications, and webinars are available on our website at licensing.csg.org, including a recording of this webinar in the coming weeks. I would like to introduce our first speaker. That is Ron Jacobs, the chair of political law at Venable LLP. He advises several national associations of state licensing boards on matters involving antitrust, regulation drafting, model laws and regulations, and legislative proposals to change state licensing laws. And go ahead, Ron. I think you're on mute.
There we go. Thank you very much, James. It's great to be here with everyone. One of my, as James said, I represent a number of national organizations of state licensing boards, one of them being NCARB. We'll hear from Mike in a minute. We've worked carefully with NCARB over the years to kind of monitor the North Carolina State Board decision and provide advice to NCARB, and so they could provide advice to its member boards. So looking forward to kind of having a little retrospective here today. So I thought maybe just as a quick beginner, we'd start with just a reminder of what North Carolina Dental Board was about, so that we can sort of level set, and then we'll kind of talk about where it's been and where it's going. As is pretty clear from its name, that the board is the state agency set up by statute to regulate dentists. It had 8 members. I think this was one perhaps factor as we talk about the case and sort of the active participation that comes from it, was that there were 8 total members, 6 of whom were dentists engaged in active practice, and they were elected by other dentists. It was not a gubernatorial appointment or some other mechanism for putting them in place. They're all elected by other dentists. 1 hygienist who was elected by hygienist, and then 1 public member appointed by the governor. And so I think that makeup is just at least somewhat useful to keep in mind as we talk about sort of active supervision and why a particular board might need to be subjected to that active supervision. Just going back to remember what the board did, that the FTC investigated. They focused on tooth whitening as the unauthorized practice of dentistry. There was originally dentists were doing teeth whitening, and then non-dentists started to get in on the act. They had locations in shopping malls and other places that was much cheaper than what the dentists were doing. And so the board voted to start an investigation overseen by one of the member dentists. There was no input from the hygienist or the public member. And at the end of the investigation, they didn't create rules or issue regulations. Nor did they follow the formal procedures for how to deal with the unauthorized practice of dentistry. What they did was send 47 cease and desist letters, on the board's official letterhead, reminding everyone that the unlicensed practice of dentistry was a crime, and implied that teeth whitening was the practice of dentistry. So they kind of acted outside the normal scope of how they would normally deal with an unauthorized practice issue. And then they actually followed up with the mall owners who had the teeth whitening stores in their malls to suggest to them that they should get rid of those businesses because they were violating the law. And so that's when the FTC got involved to investigate for the antitrust violations that were allegedly occurring there. And the board litigated all the way up to the Supreme Court. And the question focused on sort of antitrust immunity. So that's kind of the background of what was going on there. And so, one of the things that I think state boards, often wonder is, well, why are we, subject to the antitrust law at all? We're state actors. And that part is correct. The Supreme Court has said since way back in the history of antitrust that states aren't subject to federal antitrust law when they're acting in their capacity as state, the state action doctrine. A state gets to make its own policy choices. It gets to decide whether or not the federal antitrust law should apply to its regulatory authority, or whether competition or a monopoly or whatever the state might want to do is the right approach. But what has come out of that line of cases is that it's clear that states can't authorize others to violate the antitrust laws. They can't just immunize someone to say, you get to do X anti-competitive behavior. The only way they can allow sort of others to engage in their state immunity or to take advantage of the state immunity is if there's a clear delegation of authority to act in that fashion and the state actively supervises. So that's sort of the state action immunity doctrine and how it is limited or applies. But the question then, and I always think, well, wait a minute, it's a state board. Isn't that a state agency? Why aren't we considered to be part of the state? Well, what the Supreme Court said in a series of cases over time, North Carolina Board of Dental Examiners sort of being the culmination, was that the state can't just sort of can't just say that an entity is an agency of the state. It's not just their governmental character that you look at. The Supreme Court has said that the states have to make sure that anyone who's acting on their behalf sort of accepts the political accountability of those actions. And so that it's really the state making those decisions. And then what I think really gets to the Supreme Court in this case is when they're what they call active market participants. And so the Supreme Court views the dental board in North Carolina as an active market participant because it's made up of those dentists who elect themselves to the board. And so active market participant boards are not state actors unless they have the proper active supervision is kind of the overall takeaway from North Carolina Dental. Now, I think there's, some really good questions there. I mean, obviously the Supreme Court made the decision, but I think it's important to think about sort of the framework of how they got there. And part of it, I think, is this idea that the active market participants can't regulate themselves. And what I mean by that is we're actually leveled down where we're active market participants in these things. So the board itself is a state agency. It just happens to be that the state has decided that the members of the board may be active market participants. So the court sort of skips over that level that there is a state agency there. There's just individuals who make up the board, which means that the court is really ignoring the state legislative intent to have the subject matter experts be there and be the ones who are sort of making those decisions. I think North Carolina Dental Board is a really good example of a case where bad facts make bad law. That that the elected dentists were there as opposed to appointed positions. That they acted outside the scope of the board, and that perhaps if they had followed the right procedures, maybe promulgating a regulation that was subject to the state administrative procedure processes to say that teeth whitening is the practice of dentistry, then engaging the courts to enjoin those practices as their statute provided for them to do, that might have led to a better result in this case than the Supreme Court sort of forcing the active participant piece there. But again, that's just sort of, talking about what the court did and sort of why there are issues there. Justice Alito had issued a fairly lengthy dissent in the case, really making a lot of these points that we're really allowing the Supreme Court and in essence the Federal Trade Commission, who likes to investigate these boards, to really second guess how the state sets up their state agencies. So I think that's something that's important to remember. And so that's sort of the backdrop, a little bit of sort of where North Carolina Dental, how it was decided, and what sort of comes from it. And so in particular, the court focused on, well, what is active supervision? What are the things that you have to do if you have a market participant dominated board to demonstrate that you have the active supervision, which then means you get back into the state actor immunity prong of the antitrust laws, as opposed to having to look at the actual conduct at issue. And so kind of the key here is that the state officials have and that they exercise the power to review particular anti-competitive acts of private parties and disapprove of those that fail to accord with the state policy. So that's sort of the overarching construct of active supervision. And then the court gave a few examples of what sort of is the essence of active supervision, which includes things like the state officials having the power to review particular anti-competitive acts of the board and disapprove of those that fail to accord with the state policy. And this is an important point as you think about active supervision in your state for market participant boards, which is that the review is not just a procedural review. It's not just saying, did they follow the right steps? It really is a substantive review of that decision, because the court's theory is that, yes, the state can decide that they want an anti-competitive act to take place, but it has to be the state making that decision and not, as the court says, the market participants deciding to restrain competition. The supervisor has to review the substance, not the procedure. The supervisor has the power to veto or modify particular decisions. One of the things the Supreme Court says. So it's not just a high-level review, it's really going into the details. The supervisor itself cannot be an active market participant. The potential for state supervision is not an adequate substitute for actual decision-making. And one of the cases that has come out of North Carolina Dental in the lower courts is really interesting on that point. I'll talk a little bit about it. But then the Supreme Court, their last piece really, I'll say this as facetiously as possible, the most helpful point they make is it depends on all the facts of the case. So basically, we don't have a checklist. We don't know what all might be active supervision, but it's really just going to depend on the facts of the case. So in the ensuing years since the North Carolina decision, there's been I think about 109 cases that cite to the Supreme Court's decision. A lot of those are pretty passive citations, but some of them are a little more in depth. One of the ones that I think is interesting was a case from the District of Puerto Rico federal court, where they were looking at the worker compensation board that Puerto Rico had set up as a public non-sovereign actor. And they really looked at the fact there that the board members of the corporation were all appointed by the governor of Puerto Rico. So that gets back to my point about sort of the North Carolina Dental Board, where there were elected dentists to that board as opposed to gubernatorially appointed. And so I think that was one of the key things there that said, yeah, they might be market participants here, but they're when they're appointed by the governor, it's a little bit different in some situations. Then there are sort of three cases where the courts have found no active supervision. So these are antitrust cases. These are all, I think, important to remember, these are private antitrust litigation. So while we have the Federal Trade Commission looking over the shoulders of all of the state boards to make sure that they adhere to what the FTC thinks are fair methods of competition, private litigants get in the picture too. And so these three cases were interesting because of things that they found, that the courts found were not active state supervision, meaning that the boards could potentially be liable for antitrust damages. So the one in particular here, Smile Direct Club, this was another dental board case. And here the board issued rules and regulations, promulgated new rules. The governor reviewed them, as the governor is required to do, and approved them. Now, the factual question was whether the governor sort of actually looked at the rules or whether it was sort of a stamp of approval. And the court basically seemed to say it was just came in front of his desk and he signed it without any sort of particular review, which to me really got into, that's a lot of second guessing by the court to reach that decision, even though it seemed like there was a mechanism in place for the governor to exercise that active supervision. And one wonders sort of how much evidence would have to be there to show that the governor had complied with the active supervision. Another one in Texas, the Western District of Texas, there they argued that all of the rules that they promulgated were subject to judicial review through their State Administrative Procedure Act. And the court said, no, judicial review is not enough. We're talking about actual executive branch review to make sure that the decisions and the rules are what we're looking for, not just the opportunity to challenge them in court. Another case from the Fifth Circuit out of Louisiana, where a board had argued that, well, the state legislature sees everything we do and has the opportunity to veto those decisions by changes in legislation. And the court said, no, that's not enough. Anything can be changed by an act of law. Again, it's sort of specific approval of the decisions, not a veto power by the legislature down the road. So I think, these are good examples where it's important to think about what active supervision has to be. Courts seem to still be skeptical of the concept, that there's enough active supervision in these cases. So that it really does mean sort of actual executive authority reviewing these decisions on a case-by-case basis. So now I'm going to turn it over to Mike to talk about the FARB member survey and sort of the things that they found.
Okay, thanks, Ron, and hello, everyone. Again, I'm Mike Armstrong. I'm the Chief Executive Officer of the National Council of Architectural Registration Boards. So all of the 55 jurisdictional boards that oversee licensure for architects are part of our national organization. We produce the examination that is used by every jurisdiction. We produce model law and model regulations for our licensing board members to consider adopting. We are advisory, but most of our jurisdictions adopt. All are part of our model and regulatory law portfolio. And we work to facilitate licensure across state boundaries through the NCARB certificate program. And we also work to help licensure candidates understand their requirements and the qualification rules to become licensed. I'm also an attorney. So I've been very interested in what's happened with North Carolina Dental. And I am on the executive board of the Federation of Associations of Regulatory Boards. FARB is a national organization composed of organizations like NCARB for a number of disciplines, as well as state licensing boards. And we act as a forum for idea exchange, for peer-to-peer mentoring, for sharing best practices, and making sure that the larger regulatory community remains situationally aware of best ways to fulfill the expectation of state and jurisdictional governments to protect the public through licensure. So when we received an invitation to be part of this panel, we asked CSG if they wouldn't mind if we would just poll our members just to see, 5 years later, what's been the impact of North Carolina in terms of the day-to-day work of the jurisdictional regulatory boards and how the national associations of regulatory boards have seen their regulatory cultures change or modify. So I wanted to share with you some of the results of this survey and then also maybe offer some other observations tagging on to Ron's presentation of what's happened since the Supreme Court ruling. So Ron, let's go to the next slide here. And this is an overall results of the survey of the FARB membership. Most of the FARB members are national associations of state boards, but we do have some individual state boards who are members as well. And curiously, the roll-up of the overall survey results indicate that there are still 12% of our members who aren't aware of North Carolina 5 years later, the North Carolina dental case. And if you then take it down to the state licensing boards, the very entities that North Carolina dental addressed, a full 15% of the FARB membership of state licensing boards are unaware of North Carolina 5 years later. And just to remind everybody that every state licensing board of all stripes does have assigned legal counsel, either from the agency that hosts the state board or from the Attorney General's office in the state, or in some cases, they're able to retain outside legal counsel. So it's not that these state boards are functioning without legal counsel, but the fact that 15% 5 years later said they were unaware of the case is interesting. At the National Association level, groups like my organization, 100% awareness of the case. Let's go to the next slide. So about 2/3 of our respondents said that they noticed no particular changes, no layering in of supervisory activity above the state licensing board level. The most common change, if there is one, was the addition of extra steps or oversight in rulemaking. We saw in the first year or two after North Carolina dental a flurry of activity. There was, in some cases, an extra step added within the agency that hosts the state licensing board, where the procedures or the minutes of the meeting had to be signed off on by somebody higher up in the food chain of a state agency. Or in some cases, the entire procedures or proceedings were thrown over to the Attorney General's office or the governor's office for a quick review. In one or two cases, an additional agency was created or an additional organization was added to state government to fulfill this function. And I'm sorry, I'm unable to read chats and speak at the same time. So if you're trying to chat at me, I'm not going to be able to respond until I'm done with my presentation. Go back one, Ron, because I wanted to continue the previous slide there. So at the national level, our read as a community was that not much has really changed. And this was really interesting because the observation at the national level with the national associations and the state was not that much different. And then some of our licensing boards at the state level are independent. They're not part of any one state agency. They act as a sort of as a they have a direct relationship with the governor's office. And then some are part of a state agency, but no real difference. So it didn't really matter where the licensing board function was located. They didn't really see a whole lot of difference. And then let's go to the next slide there, Ron. So here's some examples of some individual responses from some of the FARB membership. So in some cases, they added an extra step, a speed bump, I would call it, waiting for an attorney general's opinion on findings of fact and conclusion of laws and final agency orders. Another response, which is probably more common here, as a board, we've become more aware of trade issues. So it was a wake-up call, I think, at minimum, to all the state licensing boards, that reminding them that they're there to protect the public, not protect the profession that they regulate. That's the protection of the profession is more of a professional society role, not a role of state government. In Louisiana, increased scrutiny. Outside entities have pushed some legislation to add extra layers of review. And then another quote here, an extra step that requires all proposed rules to go before a new legislative committee. So that's an interesting twist. Instead of going back up through the executive branch at a higher level to review the state board, in this particular case, it throws back to the legislative branch for a review to comply with the oversight. So, and I think, Ron, this is my last slide, correct? Or is there one more? I just wanted to add here that what's interesting is that, as Ron alluded to earlier, the Supreme Court opinion is quite vague in terms of prescribing specific steps. The court basically just called out what they didn't like. And also, subsequent to the North Carolina Dental Board case, the Federal Trade Commission issued what they called guidance, which I think for some of us seemed awfully presumptive, that they approached this as if they were doing a rulemaking, when in fact the Constitution makes sure that licensing and oversight of licensing is a state function, because it's not specifically called out as a federal function. So for the FTC then to issue guidance, AKA unofficial rulemaking, on the hopes that the states would then just follow in line with the FTC, sort of was a predetermined desired outcome from the FTC to work around rules and issues of federalism to, in effect, de facto regulate the function that is part of state government. So I'll leave it at that.
All right, thanks again, Mike. Just wanted to remind everyone, if you have any questions, put those in the chat and we will review those at the end and ask our presenters. Next, I would like to introduce Corey Everett Miskell. Corey is a past president and former board member for the Council on Licensure, Enforcement and Regulation, or CLEAR, and is also the former deputy director with the Colorado Department of Regulatory Agencies. Currently, Corey serves as the Colorado Director for the Latino Coalition for Community Leadership, where she helps states' agencies meaningfully connect to communities through credentialing and workforce development. Thank you, Corey.
Wonderful. Thank you so much for hosting us, CSG, and thank you to my colleagues, Mike and Ron, who presented earlier. That was a really great, I think, overview of the case, and I super appreciate your analysis. I was taking copious notes here. So yeah, I'm with the Council on Licensure, Enforcement and Regulation. I'm a past president and former board member there. So CLEAR, right, is very much like FARB. We are an agency, an association created by regulators for regulators. So we are really dedicated to regulatory excellence. CLEAR is a neutral entity in that realm. So we don't take positions or offer guidance or legal advice of any nature, but really do look at holding space for the exchange of these ideas. So with that, I'm going to go ahead and start sharing my screen here. Great. Get into presentation mode. Okay. So I'm going to go ahead and skip over. I'm not going to talk too much about the background of the case because my colleagues have already done an excellent job of talking about some of the tenets of the case, right? A few considerations. What I really want to kind of focus my presentation on comes back to regulatory structure. That regulation looks so different in every single state, right? I talk about Adam Parfit, our executive director at CLEAR, once said that through the United States, you have 50 different experiments of how to go about regulation. No two states are the same, right? And so I think that's a major consideration as you're thinking about how this case applies to my state. You have to look at that regulatory environment and that regulatory structure, which I think is why you saw some states that just frankly did nothing because they said, well, our structure isn't the same as that applied to North Carolina Dental Board. So a few considerations here, right? We've already talked about active supervision by the state, board members that were a controlling number of active market participants, board authority. Did they have the authority to adopt rules relating to teeth whitening or authority to issue cease and desist orders, right? And then board member liability and some of those things. All of that, right? If you're looking at state supervision is possible through what we call a centralized regulatory infrastructure or a non-centralized. And so, Mike talked about this earlier. Some boards are part of like a state agency and others work very autonomously or kind of independent from state government. I'm going to kind of walk through that. So here you get kind of like a spectrum of oversight, right? And I think this is really important. So looking at like the kind of like the top down, hardest type of oversight is going to be regulatory structure. That's a hard power, right? But then you get into board member selection, which we already heard come up again, right? Whether you're voted in or the governor appoints those board members or somebody else appoints those board members. Board leadership is kind of that next level. I think that's really important. It's so influential. And then lastly, board behavior. So that's obviously a much softer power as we talk about types of oversight. So the first, really digging into that hardcore oversight, right, is the regulatory structure. So within CLEAR, we kind of look at, we've created this spectrum, right, of different types of powers and authorities. So at the one end, you have kind of like what we call a Model A. You have totally autonomous boards. They're really disconnected from any type of state government or state agency. Then you get all the way to the other end of the spectrum, like a Model E, right? And you've got central agency that has complete regulatory authority. You may still have boards, but they serve in an advisory capacity only. So the decision-making is really held with the state actor, right? With the state bureaucrat, for lack of a better word. So within that, you get all sorts of mixes, right? Of different types of authority. And you have some states that centralize maybe healthcare professions, but the rest of their boards, say in like technical trades or something along that line, is not centralized, or they're centralized in 2 different agencies. Again, 50 different experiments in how to go about occupational licensing. Right, so here you've kind of got from that spectrum, a few of the responses that we've looked at, right, kind of tend towards creating greater oversight and pushing the model towards more of that centralized sort of approach, even if you keep kind of autonomous boards. So some of the responses we've seen, right, that my colleagues have already addressed, creating kind of like having decisions go through an administrative law judge, vesting power and authority with that judge so that those decisions cannot be adjudicated or overturned by a board, looking at the court system, looking at a rule review commission or legislative body that reviews and approves of rules, and then getting up to like outright veto authority, right? What's so interesting is I think from NC Dental, you started to see a lot of experimentation and some legislation coming through that kind of mixes these models together. So without completely moving my state from like a Model A to a Model C, although we did see some initiatives to do that, you're looking at how can I pull aspects of one model and incorporate that into my oversight plan, right, and strategy. So I want to look at what a few states did. So Arizona, first, they ran legislation. So they provided the right to appeal the governor's regulatory review council, to appeal a decision to the governor's regulatory review council, right? So here you have in Arizona, they're like a Model A. They have totally autonomous boards, and then they go over to a Model D with this one mechanism, right? There was an initiative to look at centralizing all of those boards under agency, and ultimately that did not pass. I just want to check in. Some people on my screen are frozen. Can you guys see me okay? Looking okay. All right, I'm seeing nodding heads. Cool. All right, cool. Next is Montana. So Montana passed a bill that provided active supervision of board decisions by empowering the Commissioner of Labor and Industry to approve and disapprove of board decisions, right? So this goes back to exactly what Ron and Mike were talking about. Here you have, Montana was definitely that middle ground, they're Model C, but they said we need that veto authority, right? So we're gonna go grab that from this extra oversight. So, and then Mississippi here, they're kind of autonomous. They have a few centralizing sort of functions, but really those boards operate very autonomously. And so here they created the Occupational Licensing Review Commission, comprised of the governor, the Secretary of State, and the Attorney General. And they are reviewing those decisions and really looking at, do they comply with the intent of state policy, right? And providing oversight through that fashion, through that body. So again, kind of going back and looking at how can I grab something that's happening in a different regulatory structure and apply it without completely changing my entire regulatory environment. So So here we have, as I mentioned, you have other policy levers, right, to look at active supervision. And some of those are hard power and some of those are soft power. So here, CLEAR recently issued a survey. I used this one, which is a survey of umbrella agencies only. So only looking at centralized states. So this does not capture non-centralized states. That's a big caveat. But I thought this is much more contemporaneous to this presentation. And so we're going to kind of review some of those responses. So the first is we asked for policy autonomous boards, are the board's decisions subject to review or ratification by any of the following parties, right? And you can see there is just a diversity. And so you have some that have vest that power with the umbrella agency director, others that vest that with the governor, attorney general's office, an ALJ, a legislative committee, any of those. So quite the mix here as we look at what type of supervision boards have implemented. And then we also asked, like, okay, what happens with the adjudication process, right? Who adjudicates hearings that are conducted after investigations? So often we see those go to an administrative law judge, a hearing officer, an occupational licensing board, and then we had this really substantial other, right? Where we dug into a lot of like text boxes, that comments that were just kind of trying to describe the regulatory structure. They didn't fit neatly into these categories. What I thought was so interesting here, though, is getting to the next one. In the event that the hearings are conducted by an ALJ, a hearing officer, or some designated board members, are those decisions subject to ratification by the full board? And the overwhelming majority here said yes, right? So the board still has ample authority to overturn a decision that may have been made by a different entity. Going back to, again, policy levers, right? So looking at board selection is also really important. And here, by and large, the majority are appointed by governors. So that's, I think, very, very important. So you can influence the people that are on the board, right? And really looking at that kind of educational process. I think one of the most important responses that states can undertake to this decision is really education and leadership. So you tend to have kind of three different levels of leadership that are on an occupational licensing board. You have the board chairperson, the board president. Typically that's a board member that's elected by the board into that position. And then you have like a board administrator. Sometimes these are called an executive director of the board, a program officer, a program manager, a program director, something along those lines. But it's really the person that kind of runs the day-to-day operations of the board. Sometimes they have a voting position on the board, sometimes they do not. And then lastly, you have legal counsel. All three of those have significant influence on board decisions, on board procedure, on board selection even. And so I think there's a lot of power that lies within this trifecta. And I think that just cannot be understated. That education and preparation of the leadership team is just important. In my opinion, not Claire's opinion, I think NC Dental could have avoided the situation they got into with different leadership. If they had different guidance, they didn't have to end up at the Supreme Court. Which takes me to my next point. I don't know why penguins was a good picture for board behavior, but that's what PowerPoint recommended, so I went with it, and it's kind of cute. Board behavior is so important, right? What we say in a public setting and how we come to decisions matters. So I can't emphasize enough, training our board members in their mission of consumer protection, looking at and emphasizing and really enforcing public meeting laws and sunshine laws, all are very important. How we got to the decision, right, and our intent in that decision is critical. So where we tend to see things, right, as we talk to some of our members about like what keeps you up at night, right? Where are things within your board that are going awry? And this comes down to board behavior, right? And so I want to raise another Supreme Court decision that I watched this very closely, of course, being from Colorado. But this decision also mentioned and looked at an independent autonomous board, which in this case was the Masterpiece Cake Shop versus the Colorado Civil Rights Commission. So they're not an occupational licensing board, but they are an individual independent commission. So here, I'll let you read through, you can go read the case yourself. But the emphasis here, right, and kind of the underpinning of the decision to rule in favor of Masterpiece Cake Shop came down to the comments the board member made on record. And importantly, were not corrected or further addressed in a public setting by board leadership, right, or some other like court procedure. And so they said these comments thus cast doubt on the fairness and impartiality of the commission's adjudication of Phillips' case. So again, we come down to, I think leadership is so important. Back to exactly what Ron had said earlier, I think the key question here is how active is my supervision of board decisions, given my regulatory structure, given my environment, right, which is different from every other state. How active am I? Because the appearance, right, the existence of oversight is not sufficient if I'm not actually using it. But you can look at kind of what is my strategy across, hard power as well as soft power. So with that, I will mention CLEAR did draft a report in partnership with the Council of State Governments and National Conference of State Legislators on US state regulatory structures. You can find that on CSG's website. We're happy to send the link afterwards, of course. And with that, I'm certainly happy to address any questions in the chat box. I will turn it back over to James.
Thank you very much, Corey, and thank you to all of our speakers. I just wanted to share my contact information real fast, just in case anyone has any questions. Feel free to reach out to me. My email address is jtatum@csg.org. I can forward any questions you might have to our presenters today or to our staff here at CSG. And a recording of this webinar will be available online in the next couple of weeks at licensing.csg.org. So if you have any questions or if you want to see the materials, including a report that CLEAR actually wrote for this project as well, that's all available there on the website. So next, I did want to ask if you have any questions, please feel free to put those in the chat. We do have a few here. One that we have, in your opinion, why haven't states rushed more to react to this decision? And I don't know if, who wants to start with that one?
I'll start. I think in the beginning, most of the folks I spoke to in the regulatory community said, as Corey just mentioned, well, our boards are all appointed by governors. So on the facts of the case, our board doesn't look like the North Carolina Dental Board, and we don't issue cease and desist orders. So the facts of the case are different. And we just think that it's different enough that it doesn't apply to us. However, if you read the Supreme Court concurring and majority opinions, the Supreme Court seemed to signal that that doesn't matter, that they are now expecting that every regulatory board will have independent review. And then the other thing I've heard, and sometimes I've heard this from legal counsel from state boards as well, what does the phrase anti-competitive act even mean? Does it mean just cease and desist orders? Does it also mean disciplinary actions? How narrow or how broadly should this be interpreted? So I think, those of us trained in law, bad facts make bad law, which I think also is what Corey was alluding to. Absolutely, if the North Carolina Dental Board had not gone outside its scope, its legislative scope, and issued cease and desist orders, if those members were appointed by the governor versus elected by their fellow dentists, this whole sense of industry interest or industry protection wouldn't even risen to the level of review. So I think a lot of jurisdictions just felt like, let's wait for some more case law on this because our fact situation is so different than the Supreme Court, despite what the Supreme Court seemed to be suggesting. That's Corey and Ron, you may have a different take on that.
No, I think that's totally agreed. Corey, go ahead.
No, I was gonna say 100% agreed.
Okay, great. Thank you. Let me see. So we had a question from Stuart earlier. I don't know if I can paraphrase effectively. I will try. An alleged antitrust board action does not have to have active supervision by a higher state authority to have antitrust immunity if the board is acting, quote, pursuant to a clearly articulated and affirmatively expressed state policy to displace competition, end quote. Can you give us some examples of such a clearly articulated state policy?
Well, I guess I would say first, and Corey or Mike, feel free to disagree with me. It's a two-part test. There's to be the clearly articulated policy and have active supervision in order to get the state actor immunity. So I think it's not, you can't, even if there's a clearly articulated policy, that alone doesn't get you enough. You still have to have the active supervision. I think the clearly articulated policy, and I think that question I saw in the chat box had an example of where if teeth whitening had already been defined by the legislature as the practice of dentistry, that might have been a policy that had been established by the state, or it's a policy that the board has very specific authority to issue cease and desist letters for the unauthorized practice would be another example, where they're giving the board certain authorities to do things. Corey, happy to have you chime in and if you have a different take on that.
Yeah, I think that other that's kind of coming to my head is, I think you saw several, I agree with you, there's this active supervision, right? And so having the articulated policy is very important. And as is how we go about implementing that policy. And I think that's one thing that came up with NC Dental is you had the board that was in, I would say, vulnerable territory for any occupational licensing board where you're doing one of two things. You're prohibiting somebody from entering practice, so that application and entry to practice is very important, or you're removing somebody from practice, right? So someone has a license and you're taking it away. And then lastly is cease and desist, so regulating people that aren't dentists, right? So with any of those, I think there are several procedural matters you could utilize to avoid this situation, right? And to clarify the state policy regarding regarding the matter. In this particular case, right, perhaps sending to an administrative law judge for their opinion on it before executing on the cease and desist orders may have been sufficient coverage. So I think, yes, I agree that it's the policy and where the rubber hits the road.
I had an opportunity to actually talk to a former FTC commissioner and who had been several administrations previous, and also to an attorney at the FTC who had just come out into private practice, but was there when this all came down. And it's my understanding that the FTC for decades had been increasingly concerned that that state licensing authorities were inappropriately restraining trade and acting outside their real scope. And they'd been looking for a case where they thought they could go to court. And this was this perfect storm where the scope was very muddy in terms of what the dental board could or couldn't do. The members were appointed by industry rather than governor. It's almost like it was tailor-made for the FTC, and it's something they've been waiting for a really long time. And so I also know the attorney that was part of the firm that defended the North Carolina position. And I guess they were so convinced that sovereign immunity was such an impenetrable theory that pretty much the state would not be liable. And they kind of hung their hat on precedent based on sovereign immunity, combined with the fact that their interpretation of scope was that they did have the scope to issue these cease and desist orders. And that clearly was just a factual error according to the Supreme Court. But the sort of context of why the FTC went after this, what was their motivation, and what was the mindset of the folks in the state of North Carolina, because Corey's right, at any point, the state could have just modified its approach, stepped away or reconfigured itself, and we never would have had this case to begin with.
All right, thank you very much for those responses. We have another question here. Some states have restructured state agencies that house licensing boards and appointed advisory panels of professionals. Do you think this was an overreaction?
James, can you read the last part of that question one more time?
Certainly. Let's see. States have appointed advisory panels of professionals. Do you think that this was an overreaction?
Depends on how you want to interpret the Supreme Court decision. I mean, the Supreme Court said create some sort of independent supervisory authority. Well, the easiest way to do that would just be to provide someone else that the state board could show their proceedings to, and within a matter of days, they could approve it. You create a whole separate agency, you get into a whole other bureaucratic process that could end up taking a really long time before these decisions are finalized. So from a efficiency perspective, not to mention expenditure of taxpayer dollars, it seems like that's a bit of an overreaction. But I'm not sure where to judge that.
That's fair. And Ron and Corey, did you have any thoughts on that, or should we move on to the next?
I mean, I think I agree. I think deciding on whether that was an overreaction totally depends on the other type of oversight you already have within your state. So again, I think you really do have to look at this at just looking at your state, not necessarily comparing yourself to other states, because the regulatory powers are so varied.
I agree.
Thank you.
I think there's an added risk when state licensing boards don't have their legal counsel present during their meetings. And I know in some states, there isn't enough money to go around, so that it's sort of an as needed, oh yeah, we'll send the lawyer to this meeting because there might be something, but it looks like nothing on the agenda is going to require legal counsel, so we won't be there. Or if they're reaching into a pool from the state attorney general's office and people are on a certain rotation. I've gone to state licensing board meetings where there have not been legal counsel present during the meeting. I think that's a risk that people should try to avoid.
Thank you. Let's see, the next question we have, in terms of trends, have there been more challenges from the FTC or others against state licensing boards since 2015?
So what I would say is I think that I felt like there's a slight pivot in what the FTC has been doing. Maybe less from board action, more toward just sort of the concept that licensure is not necessary. The FTC also has a very, on both sides of the political spectrum, we've seen sort of this desire not to have licensure for certain occupations or to make it more portable because it's seen as barriers to entry. So I would say it's not the exact same thing, but it's sort of maybe two sides of the coin that we've seen from the FTC and where they've been focusing on things.
At a FARB conference, maybe 2 or 3 years ago, a senior staff person from the FTC spoke, who was, this was during the Trump administration, and she was quite direct with us, saying that it was the intent of the FTC to continue to litigate on this issue because they believe there were more bad actors out there.
All right, thank you. Let's see, and the last one that I have here, are different licensed professions, i.e. non-medical, likely to be handled differently under this precedent?
I think they'd all be the same for the most part. It's really a function of how the boards are structured. And I know, from Mike's perspective, the architecture boards generally have architects that make up the boards in various formats. So I think it applies across the board.
I think it helps, quite frankly, when there's a multidisciplinary board with a strong percentage of what we call consumer members or public members. In California, for example, all the licensing boards in California have to be 50% consumer or public members. And in many jurisdictions, in the case of architecture, we're co-located with landscape architects, sometimes engineers, sometimes interior designers, geologists, surveyors. And I think based on the tenor of the Supreme Court decision, the more you get a mixture of professionals from other professions, but who still understand the value of licensure and the importance of protecting the public, I think it strengthens the argument that there's not been an industry interest in the decisions that have been made.
I'll just offer, I completely agree with that. I think that was one of the, looking at board structure, board representation, right? The umbrella board, so grouping and public member majority. I think that was a really important response that some states made that was rather innovative. But going back to the original question, frankly, no, I absolutely, in my opinion, I don't think there's going to be any difference depending on the type of profession that's being regulated. Because at the end of the day, while you do have different regulatory structures in each state, there is common ground that are shared by almost every single board, which is that mission of consumer protection and that either that power or the purpose of the board. And so those things are shared, and that's what this decision really came down to.
James, did we answer Stuart Williams's chat that came up when I was presenting originally? I don't know if we got to that one or not.
We did. That was one where I paraphrased a bit. Stuart, if
Okay.
there's anything that was unclear about that, feel free to reach out to me. We are bumping up at 3. So at this point, just have my contact information shared again. So if you think of any other questions or have any questions for our presenters or need any resources from us, please reach out to me and we can always set that up for you and get you taken care of. I really appreciate everyone coming to speak today, Ron and Corey and Mike, and all of our guests as well. Thank you very much. And I hope you all have a great week.